Hello, my name is Mary Mack. I'm the Executive Director of ACEDS, the Association of Certified E-Discovery Specialists. We are delighted today to bring you a webinar from our fabulous Gold affiliate, BIA. We are going to be talking about social media discovery, find the smoking gun. We all know social media is very, very powerful. As a matter of fact, it doubled our attendance overnight. From some things that went out. So we're absolutely delighted to take a look at social media as applied to e-discovery. Your questions are very important, as always. The Q&A tab is down at the bottom of your screen. And if your question's not answered within the webinar, the good folks from BIA will reach out and answer your question afterwards. Starting out, it's my pleasure to introduce ACEDS, Mark McDonald SEDS, Senior Vice President of Business Development at BIA. He's got over a decade in e-discovery, including some advanced topics around data preservation, forensic investigation, computer forensic investigations, advanced data analysis, managed attorney review. And he also manages the client contract negotiations and high-level account management for BIA. He has brought with him another SEDS and a wonderful long-standing contributor to our ACEDS community, and he will be moderating, hosting, and taking it away now. Welcome, Mark. We're so glad to have you back.
Thank you very much, Mary. That was quite an introduction. I owe you lunch for that one. We're excited to be here today, as always, and to bring this Power Pack lunch to you. This is a shortened version, 30 minutes, so we appreciate everybody's coming. We've got Barry Schwartz, one of our senior advisors, and Josh Serra, who leads BIA's Social Media Discovery Services Division. Barry, why don't you take it away, and I will follow up at the end if we have any questions that we get time to get to. We'll bubble those up to our presenters. If not, they'll be on the BIA blog, and we'll send everybody a link. Barry, please feel free.
Thanks, Mark, and welcome everyone to our presentation. The first thing we want to discuss is the ABA model rule of competence. And to highlight this rule quickly, it's up to attorneys to be abreast of changes in the law, including the benefits and risks associated with relevant technology. And to further that along, in 2016, the DC Bar Ethics Opinion was issued, number 371, that said that it's incumbent upon attorneys to be competent and zealous in their representation, which may require the investigation and potentially relevant social media postings of adverse parties and their counsel, other agents, and experts. So that's a very topical point, obviously, to our presentation today. And then one of the common threads across most of the bar associations now is the notion of technical competence. California, sorry about that, whoever had the music on hold. California has issued its formal opinion that's been often cited, 2015-193. New York County Lawyers Association has their formal opinion as well, that it's the ethical duty of technical competence with respect to the duty to protect the client's confidentiality, including confidential information from cybersecurity risk and the handling of e-discovery. So it's out there as it's a known entity or a known requirement that today attorneys should be well abreast of social media and its impacts on their various litigations. And there are a lot of preservation obligations associated with social media. I've got several cases listed here. I'll just high spot them for us. The Cajamarca case, the first one listed, counsel failed to advise their client to preserve their Facebook communications. The plaintiff in this case was that person, and she deleted her Facebook posts, and the end result was that the defendant, Regal Entertainment Group, obtained an adverse ruling and actually was awarded money for the failure of the plaintiff's counsel to advise appropriately. Unfortunately, Regal still lost a multi-$100,000 settlement, but they did recover several $1,000s on that motion. In the second case down, the Catterall case, interesting case. The defendant in this instance, had deleted Facebook posts that showed that they were infringing upon the plaintiff's trade style in how their restaurant was designed and so forth, and the court required the defendant to restore the Facebook posts because they could still do that because they were still within the time frame. And as a result, the plaintiffs won their position. And then the poster child for dealing with social media is, I believe, the Lester versus Allied Concrete Company, which this case, again, is often cited and often talked about in webinars, but it makes the point that counsel had advised their client to clean up their profile, and as a result, the attorney in the case was sanctioned for over $500,000, and their client was also ordered to pay just under $200,000. So it's out there, the courts are aware of it, and there are all sorts of obligations regarding protecting and maintaining e-discovery. And some other cases, and again here, given the interest of time, I'm going to high spot these as well. And the first case is the AvaPoint case, where claim of false and defamatory and deceptive tweets by the defendant. The court allowed the defendant to enter those tweets into evidence. And additionally, and we'll talk about this in a little bit as well, the defendant had created a fake LinkedIn account, and the fact that the defendant had done that was also allowed in as well. The Parker case is a case where a criminal was out on parole and had posted additional information after the parole was in effect, and showed on Facebook and so forth that the plaintiff was, or the party, Parker, was had guns and all sorts of things that were banned as a result of the parole, and ended up back in the slammer for another couple of years. And I'm going to move on to the next slide. And I believe you're all going to get copies of the slide deck. The citations are here, so you can dig back into these cases as you see fit. One of the important cases here that I want to highlight, though, is this Gatto versus United Airlines, because it's very poignant for, in my opinion, one particular reason, and that is the relevance of terms of service in the social media platforms that all of us are familiar with. In this instance, Gatto had a personal injury suit against the airline and had unfortunately deactivated his Facebook account. And the interesting thing here is that Gatto had not deactivated the account before the litigation had started, but had noticed an unusual login to his account, and as a result, closed it down. And the unusual login or viewing of his account, because you can see that on Facebook, who looks at your detail, was defense counsel looking at Gatto's public posts on Facebook. And what happened was the account was closed, and defense counsel said it needed to be reinstated. However, in this instance, Gatto never reactivated the account, and the information posted on Facebook was no longer available, because at that point in time, Facebook had a policy where when an account is deactivated, that data disappears after 14 days. Now it's 30 days or so. And I say or so because Facebook deactivates within 30 days, but the data isn't quite gone for a period after that. So it's important to know what your terms of service are, whether it's a Salesforce.com account or it's Twitter, or any of the other commonly used social media platforms, read those terms of service. They come into play all the time. And here, this I just pulled from Facebook's site last week. They now have a 30-day policy, and they do say that it may take them up to 90 days to do the data deletion. However, it's not going to be accessible to you any longer after the 30-day cutoff. Maybe you can break into that 90-day frame and collect that data, but probably not likely. And then this slide is just representing the number of and types of cloud resources that are out there of a social media ilk that that Josh will be talking to just in a couple of minutes. And one of the other things to be aware of is in Twitter, there is the ability to observe tweets as they happen pretty much in real time with some of the tools that are out there. And in this case, we had a client who asked us to monitor jury traffic within a certain geographic radius of a courthouse. And this is what we saw, even though the court had instructed the jurors to not be talking. And unfortunately, they were. And this particular bit of information just shows the wide prevalence of social media today. 1.5 billion daily users of Facebook, 126 million daily users of Twitter, and it just goes on and on. And it's out there, and it's in every one of our lives in some aspect or another, and it is implicated in many, many of the litigations that we see today. And we're starting to bump up on some time considerations, but I will highlight these as well. Over half of attorneys today see that social media is implicated in some of their litigation and some of their efforts now. And a couple of the cases I have listed here, the Foreman versus Henkin and the Hinestrosa cases are very, very similar. In each instance, the plaintiff alleged an injury of some sort, brain injury in the first case, slip and fall in the other, and the plaintiffs did not want to disclose their social media posts, and in both of those instances, the court ordered that they should be admissible, including the private posts. And in both of those cases, the courts limited the time frame for the search of the private posts to a year before and a short period of time after the incident occurred. And the Hummingbird case is interesting because it was an early case from 2007, and the court said, with respect to both Facebook and, yes, MySpace, that there was no expectation that the communications would remain confidential after, as I mentioned earlier, examining the terms of service and the privacy policies for both Facebook and MySpace. And this graphic just shows the ever-expanding and widely used aspects of social media, whether it be email, social media, such as we know with Facebook and Twitter and LinkedIn and so forth, instant messaging, text messaging, as well as internal social media platforms that can be implicated. And some of the big ones that are in use today are Slack and Teams and HipChat, which I believe is slowly disappearing, and Google Plus, which is sunset. However, some enterprising individuals have been able to scrape Google Plus before the sunset at the beginning of April, and so all the public posts on Google Plus are available in an archive situation. So that's out there as well. And so some of the do's and don'ts. It's okay to examine public social media profiles. You should consider it in most every case, and in BIA's opinion, you should retain an expert to collect and preserve that data. And some of the don'ts: don't friend or follow the opposing party or jurors. Don't simply print the social media profiles, and Josh will talk in some detail about why that is something you should not do. And obviously, don't hack social media accounts. And as I mentioned with the pretext, with the LinkedIn fake account, don't pretext or impersonate to gain social media info. Specifically, you could run afoul of the Gramm-Leach-Bliley Act or the Fair Debt Collection Practices Act. So how do you even begin to start identifying and evaluating and handling the ever-expanding universe here of this data? And so some of the things that Josh will talk about are best practices, developing a repeatable, defensible workflow, which is something we talk about all the time here at BIA. If you are consistently doing something time after time after time, that in and of itself, and you're doing it correctly, that becomes part of your process and procedures, and it's defensible. And use an expert to aid in your effort. So, Josh, here you go.
Thanks, Barry. So I'm just going to go into a little bit of how we do our social media discovery at BIA. Typically, what we run most with our clients is our straight social media search. That's where we're going to be just doing background search on the internet for any profiles of whomever we are hired to find. We'll collect all the profile information that's publicly displayed, and we'll turn that into a physical report for our clients. When we extract that data, part of what is also collected is all the metadata from the profile, and that gets authenticated using hash values. I'll go talk about hash values a little bit later. Essentially, the hash values is what's going to authenticate and allow this into evidence, unlike a screenshot would. Another option we have is profile monitoring. Similar to our straight social media, we'll use the profile monitoring. We'll find those profiles, create that report. We'll check on these profiles weekly, monthly, whatever we're asked of, and we'll look for those changes, see if anything's possibly being edited or deleted. We're kind of looking for, potential hiding of evidence to establish some culpability. Similar to that is jury monitoring. We'll actually do that same profile monitoring with the jury monitoring. That's one aspect of it. Another one would be during voir dire, we will help create character profiles that can assist our clients in their choosing of jury. We'll use things like the criminal background checks along with their social media profile, try to establish some sort of regular character profile, how this person might react to certain topics, or maybe even discover how often they go on. If they go on daily, you might be more likely to go on, while you're a jury member when it's against court rules, and obviously that could end in a mistrial, kind of similar to what's happening with the El Chapo case right now. Lastly, we will also do news and article monitoring. It's essentially exactly how it sounds. We will monitor the internet for any recent news articles for the subject that the client would like us to look for, and we'll check back on that periodically. And moving on, we'll get into kind of our workflow here. Essentially, we will start with the background report. This kind of confirms identities. We'll use things such as their family members, deeds, all that will help us to confirm that the profile that we're looking at is actually theirs. Assuming you can see their friends or find similarities in the likes on their posts. From there, typically either go to Google or we'll go straight to Facebook. We find that Facebook is the most helpful platform to find because of the way they list their friends. They use real names often, and maybe even you might find a nickname or something that's used that will help you find profile on a different platform. When they have pictures, that additional resource to help you find other profiles. Sometimes you can identify other profiles through those pictures that are listed on Facebook. We'll use a search engine, typically at the end, such as Google or DuckDuckGo, and kind of search for the name. That's kind of our catch-all to make sure we're not missing anything. Typically, once we find these profiles, we'll provide them to our digital forensics team. We'll have them put these URLs into their extraction program. What happens there is, as the program's extracting the data live, it assigns hash values to it. Hash value simply is a digital fingerprint. This allows you to corroborate that the data is there and that it is untouched. If you run that report again and the values have changed, that's going to indicate that something's been edited, something's been deleted, something's been added. MD5 and SHA-1 algorithms are typically the most popular for hash values. The report comes out with that metadata and its associated post or other information on the profile, such as place of living and pictures, friends, etc. And it matches the metadata with that profile image.
And Josh, let me step in here for a sec. This metadata table that you see now, this is only an excerpt of probably 100 different factors that we capture when we do social media collection. And this is one of the key reasons, if not the primary reason, to not just do a screen capture of social media. You miss this information, and the metadata, and this is a Facebook collection, however, it's similar for other social media collections, so it's an important aspect that we don't want to miss when you're doing, or when we're doing a social media collection. This makes it entirely defensible and supportable in court. Josh, I'll move on to the next slide for you.
All right, so running this, we run into a lot of random difficulties and setbacks. One of the most common ones are the naming of the subjects. You come across somebody such as a Robert Smith, obviously there's going to be a lot of Robert Smiths on social media platforms, and it's up to us to determine which one's the correct one, if we could even find the correct one. Similar to that is quote-unquote ethnic names. Often we see something that looks very original to our American eyes, and come to find out that it might be an extremely common name in Spain, or if you get a name like Mohammed, which is known as being one of the most popular names on the planet. It makes it very hard to distinguish which one's correct. Sometimes you run into having to determine which name is first when you're looking at the profiles, because of the way that naming works, say, in China. And occasionally we run into foreign alphabets where the person's name's written in Hindi or something similar to that. Nicknames can be another place of trouble. You might come to find out that they have a nickname they go by and all their social media profiles are under that nickname. That's kind of why Facebook's one of the best places to start. If you find a family member that can lead you to your subject and find out that they have a nickname that can help you find other profiles. Divorcees, widowers, oftentimes the background reports don't necessarily give you the name they're using for their profiles, whether it's hyphenated, whether they're using their married name or their maiden name. Obviously, private or protected accounts, there is some public-facing data typically. We can only collect the public-facing data. Oftentimes, though, it's not enough that we would collect it. There's just not much there to work with. Searching using the platforms can be extremely difficult, especially Facebook, for instance. They have filtering capabilities, yet the filtering capabilities often work against you. Security updates, it's something we're constantly battling with. The program's set to work with certain security standards. If those get updated, then our program either needs to wait for an update or we need to find a workaround, such as manually operating the extractions. And then sometimes the program can crash, etc. And if you're running these extractions for days, you get set back, 5-7 days and have to restart it.
Josh, let me step in and just identify that there are some field-specific social media sites that may be implicated in your matter. There are medical practitioner-specific platforms. We named 3 of them here. They're similar for other professionals, and it's something to be aware of. And how you ferret that out is to ask custodians as to what other social media platforms they might be using, and they may be relevant in your particular case. Lastly, with respect to social media collection, and we talked about this with the jury selection issue, there is the ability with technology to draw a radius or circle or a rectangle around a specific point and track all Twitter conversations in that particular geographic area. And as Josh had mentioned, in the El Chapo case, there were jurors talking on Twitter, and that may lead to a mistrial in his instance. And it's something that it's very informative, interesting, and can be very effective. A couple of war stories to go through very quickly. We did a social media collection a little while ago and found a lifeguard who had claimed severe injury, and she was indeed injured, ruptured her Achilles tendon, and said that she was now unable to enjoy herself in her normal social activities and exterior activities. And we found through rigorous investigation on social media, through friends and family, that she was taking exotic vacations after the injury, climbing waterfalls, doing diving, and so forth and so on. And she clearly was not injured to the extent that she had claimed. In our next story, parents had claimed their child had received an injury at birth that had severely limited the child's athletic ability, and in reality, that wasn't the case. The child grew up attending football and soccer camps, was able to run a 100-yard dash well beyond his age, and so again, social media allowed us to refute the claims. So, as I mentioned a little bit ago, custodian involvement is key, and the custodian is likely to be that person who's most knowledgeable with the client, able to identify and segregate relevant information. And so, again, talking with custodians is a very, very important thing to do at the outset of your case, and as it's ongoing. It's important because they're able to do the best with respect to data identification. And how BIA does it and how we would recommend it for most people, most clients, and most cases is to interview the key custodians. But when you've got more than just a handful of custodians in your case, utilize a custodian questionnaire that allows you to reach out to all your custodians at one time with a set of questions. You may stratify it so that marketing people have one set of questions. The engineering people may have a different set of questions, but then the report comes back as where you can compare and contrast the answers. So to that point, Mark, I'll turn this back to you. Thank you all. If we have any questions that we have time to answer, we'll do that. Otherwise, thank you all for attending. Mark?
Barry, Josh, thank you both very much. That was a lot of information to get through in a short period of time. We're a couple minutes over our cutoff time, but any questions that did come in, we'll put up on the BA blog, as I said before, and pass a link out to everybody who joined us today. And thank you very much for joining us. Hopefully we'll see you again soon on another ACEDS webinar. Have a great day.